Stop asking for other people's fee agreements. Hi, this is Brita Long. I am the author and creator of The Happier Attorney, and this is the channel where we talk about flat fees and mindset and how you can have just a better life as an attorney. And today we are going to be talking about fee agreements in flat fees and why it's a horrible idea to ask other attorneys for their fee agreements. And I get it. I totally get that on first blush, especially when you're starting out using flat fees, it would be tempting to think that, oh, if I get the fee agreement, I can figure out the rest. Like that's the pivotal part. And I certainly know that it's customary in the legal field to share fee agreements. And my first fee agreements came from other people. I get it. But here's why that's a mistake. The first issue is that most of the time when people are using flat fees, they are not using them properly. I've talked to attorneys who have used flat fees for years, and they've certainly fleshed out some of the issues, but there's still gaping holes in how they're doing things. And then there are other people who haven't used them for very long. They're still making big mistakes. So it's really the blind leading the blind. And so if you get someone's fee agreement and they say that they've been using flat fees, you're going to think that that fee agreement is going to cover you. And I can tell you it probably won't. Okay? And it might get you in some trouble. The second reason is, especially when you are in a Facebook group, my Facebook group, Attorneys and Flat Fees, we have people from all over the world. And people will just say, oh, does anybody have a fee agreement for blah, blah, blah? Okay, well, you don't know where that person is. Say they sent you a fee agreement. You don't know that that person's jurisdiction, their RPCs, are the same as yours. They're probably not, okay? And you don't know what the necessary ingredients are in the fee agreement where you are, okay? So the biggest issue is that it is necessary for you to work through the process of creating the fee agreement, of adding the ingredients, and knowing what they do and what your boundaries with your clients are. There's no substitute for doing it yourself. Maybe with a bit of help, but there's no substitute for doing it yourself. And here's a prime example of that. When I started my own practice, I started with flat fees. And this was before we had great software for family law. And so I would have to calculate child support manually. And, it took some time. But I learned so much from that process. So much more than just reading what the statute said about child support, when you actually got to see it in play. And then we get software, great software, and you plug in some numbers and it spits out a number and on you go. And let me tell you, when I would practice, when there was opposing counsel, and we would be talking about child support, I cannot tell you how many times it was very evident they did not know how they got that number. They had no idea how the computer spit out that number. Well, I did, because I had done it manually. Same thing. There is a part of this process that you just have to do yourself in order to really get it. Okay? So, what does need to, and you're like, okay, well, great. Then how do I do that? Now, the first thing I will say is that all of this is contained in my book, The Happier Attorney. It's available on Amazon. The Happier Attorney. Really simple. But your fee agreement, and this is for flat fees, you have to know your state's RPCs in regard to fees. I hope that goes without saying, but it's critical. And your fee agreement is going to be based on that, regardless of what anybody else says. The first ingredient is it is critical for you to know and fully understand whether this fee or what part of the fee can be earned upon receipt or not. Critical. Some states, and I'm just talking about the US, I don't know any other countries. Some states in the United States, you can say the fee is earned upon a receipt. Many you cannot. You have got to know the difference. And likewise, that will determine whether your fee can go in your operating expense account, your bank account, or in your IOLTA. And when it goes in your operating or when it goes in your IOLTA, based on the earned upon a receipt or not. Critical. You have to know that because you can't mix funds. If it's your funds, if it's earned upon a receipt, it can't go in your IOLTA. Ever. Don't do that, as you well know. Likewise, if it's not earned upon a receipt, then you had better be very clear in your fee agreement and in practice as to when it is earned. And when it is earned, you better be transferring it to your operating account. I have had clients who essentially forgot funds were in their IOLTA and they had been earned for a couple months. That is not a practice you want to get into. Not a practice. And it certainly would be better than the other way around. But if funds are in your IOLTA, they aren't yours. And if they're yours, you better get them the heck out. Okay? Your fee agreement should also be very clear that you are not tracking your time. Now, there's other videos about tracking your time. Don't get hung up on that. Even if for some other reason you're tracking your time, you're not, it needs to be in your fee agreement. You know, you are not charging based on your time. You are not sending out statements, period. And sometimes when things go wonky in a case and people want their money back or people are unhappy, especially like in family law, they will go back even in a flat fee and go, well, I'd like an itemized statement. I'd like to know how much time was spent on this. No. Don't fall for that. Go back to your fee agreement. As you will recall, I'm not sending statements out. I'm not creating statements. There you go. This is so important, this ingredient. And a lot of attorneys miss this with flat fees. You have got to be crystal clear on when this agreement ends. When you have earned the fee and when the agreement ends. And I would propose that you have a specific date in there. It can be an actual date or it can be 6 months from the signing of the agreement or 8 months, whatever. Okay. And an event. We settle, we get through mediation, an event. Whichever occurs first in time. Okay? Because if you don't say whichever occurs first in time, things can happen and, okay, say you don't settle and it's a year in. Okay? You don't want to get stuck in the case. Okay? Or let's say you had an 8-month agreement and you got the work done in 2 months. You don't want to be sitting there hanging out. So you need both and whichever occurs first in time. Okay? Yes, you need the regular CYA things in your agreement that you would have in any other fee agreement. You also want to be crystal clear on client behavior, what they can expect from you and what you expect from them. Clear boundaries. This is what an emergency is. This is what it isn't. Yes, your office hours and blah, 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 but I absolutely always had, and in estate planning, it didn't really come up, but in family law, it sure did. If you lie to me, I'm out. If you are self-sabotaging, I'm out. If you're not taking my advice, I'm out. And obviously, like, they are in charge of settlement, they're taking the advice, it would have to be extreme. But, you know, if you're making things more difficult, if you're self-sabotaging, and of course the catch-all, and for any other reason, I'm out. Okay? And obviously you have to comply with your RPCs about when and how and all of that. But I went over that with the clients. This is where I will be out. Okay. So with that, remember that people can only remember 4 to 7 things at a time. That's why telephone numbers are 7 digits and they're broken up. So you have got to go over the things that are truly important with your client in the fee agreement. But don't go over everything. Don't throw in the kitchen sink because they can't remember it. So if something is really important, like the date that you're out, the rules for your clients, you need to go through that with them. But don't go through everything. And while the fee agreement is key, it's more important for you to understand the ingredients in the fee agreement and to do it yourself and how you got there. Because fee agreements can change. Facts can change. Things can change. And you need to be able to change your fee agreement to coincide with those changes. Okay? So don't make this bigger than it is. Don't make it more difficult than it is. It really, if you have any experience as an attorney, it really shouldn't take you more than half an hour at most to draft a good fee agreement, because I assume you have some templates out there for regular fee agreements. Look at the Happier Attorney. If you need more help, contact me. If you've gotten any value out of this, please like, subscribe, comment, so that other attorneys can find this as well. So this is Brita for the Happier Attorney. I hope that you got some value out of this. And fee agreements are, of course, vital, but don't overthink it. Don't overcomplicate it, but make sure you have the key ingredients in there. And if you would like to get more information on working with me, go to britalong.com and or join the Facebook group Attorneys and Flat Fees. So we will talk to you next week. Take care.